All right, I'm gonna call the seventh meeting of the Rhode Island Ethics Commission to order. Have a quorum present. The first item on the agenda is a motion to approve the minutes of the open session held on April 14, 2026. Is there a motion?
So moved.
Motion by Commissioner Rabideau, second. Second, Commissioner Callahan. Roll call vote, Commissioner Susie.
Aye.
Commissioner Peterson, I think you're abstaining.
Yes, abstain.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Mr. Ricci, yours, yeah, abstaining. Commissioner Strauss.
I think I was here.
Okay. I missed that you weren't here. And the chair votes aye. The next item on the agenda is the director's report. Mr. Graham.
Good morning. Let's see. So we just go down the list in complaints and investigations. We still only have the one that is technically pending, which is the Thorson complaint. I'm informed that written decision is in the process of being drafted and probably expected to be circulated to the commissioners who participated in that decision in the next week or two. Yes.
Maybe a little quicker.
Advisory opinions, we have 9 pending as of this morning, and 6 of those are on today's agenda. So we're doing great addressing these as they come in. We had, I think, 9 APRA requests since the last meeting. 8 were completed within 1 business day, as we always try to do. The one that took a little more than 1 day, but of course less than 10, was just a really complex and vague request where we had to, as sometimes we do, go back to the requester and say, what are you really looking for here? Once we got that under control, we were able to finish that APRA request also. The majority of these were related to advisory opinions. 5 of them had to do with advisory opinions, either copies of the opinion themselves or the request letter. 2 related to recusals, 1 related to financial disclosure. Particularly, we had a press inquiry who wanted to know everyone who would ask for an extension for financial disclosure, which we were able to provide. And then 1 just related to multiple categories, but only financial disclosure statements were responsive. That was the vague request that I had mentioned earlier. Let's see, financial disclosure. The deadline has come and gone. As I mentioned at the last meeting, we have been sending out reminder emails, including on the deadline day. We'll be sending out another reminder email to those few people who haven't filed this Friday, unless you have an extension, in which case you won't receive a reminder email at that point. The other thing is, at this point, with the deadline passed, our investigators will now start the kind of arduous task of making phone calls to town clerks, to charter school administrators, to fire district administrators, to try and shake the tree a little bit before we. And that usually works pretty well, but it's labor intensive. As of this morning, we're at 86% compliance, which on the one hand, it's post deadline, 14% non-compliance. That doesn't sound great. On the other hand, this is exactly where this is correct for this time of year. I'm not the least bit worried about it. I think we're exactly where we were last year, and we finished at 100% within a reasonable amount of time. So I expect that to happen again this year. Then just on to general office administration, our next regular commission meeting won't be till June 2nd. So we've got a bit of a break between this meeting and the next meeting, which probably means that June 2nd meeting will have fairly extensive agenda with advisory opinions and even potentially initial determinations if new complaints come in. And then I will note that we do have the declaration of candidates an election year. So June 22nd, 23rd, and 24th, people will be filing their declarations of candidacy, which will add about another 500 financial disclosure complaints, not complaints, financial disclosure statements that will need to be filed in July. So Right when we're getting into the fun of summer, things are gonna get a little bit busy here again in July, but that's fine.
I think the planes will start coming in as well.
Maybe. Election years are always, you never know what's gonna happen. The last thing in general office, you'll notice in front of you is a new version of the Code of Ethics. We just reprinted the code, which we do every few years. This time we reprinted it so that the new gift rules that you enacted are now part of the code instead of as an insert. While we did that, we also went through, when I say we, it was really staff attorney, Papa, who went through the entire code, looked for any typos or technical issues, and we made several technical revisions to fix anything that there wasn't a substantive issue, but maybe the numbering for some reason got out of place. So hopefully we've got a nice clean copy that should last us until the next time we do some ruling. Feel free to take those with you if you care to. If you don't, just leave them on your desk and take care of them. That's all I have.
Thank you. Anyone have any questions for Mr. Grammon? Have a sign up sheet? Next item on the agenda, so the advisory opinions. First advisory opinion sign up is Doug McLean. Morning, sir.
Good morning.
Morning, everyone. The draft for this petitioner is at tab C in your binders. Welcome, Mr. McLean. The petitioner is the Director of Planning and Development for the town of Coventry. In his private capacity, he works as a planning consultant. He seeks an advisory opinion regarding whether he is prohibited by the Code of Ethics from continuing to, first, perform his official duties relating to the appeal of a recent Planning Commission decision approving an application for the village at Tyoke, and second, from continuing to work in his private capacity as a planning consultant. The petitioner was appointed to the position of Director of Planning and Development by the town manager almost 3 years ago. His public duties are outlined on page 1 of the draft. They include, among other things, overseeing the planning department staff, facilitating acceptance and processing of planning applications, and conducting administrative reviews and drafting staff reports to offer guidance on planning applications. The petitioner's regular work hours are Monday through Friday from 8:30 a.m. until 4:30 p.m. He does also regularly attend Planning Commission meetings several evenings each month. The petitioner represents that he recently provided a staff report and recommendation to the Planning Commission relating to a development proposal known as the Village at Tyoke. This is a 162-unit preliminary plan and comprehensive permit application proposed by 232 Realty Associates, Mr. Robert DeBlois. The application was approved by the Planning Commission in January of this year. An appeal was timely filed by both Mr. DeBlois and a group of 12 or so abutters to the subject property, and that matter is currently pending in the Rhode Island Superior Court. The petitioner informs that his public duties during the appellate process will include providing information and access to documentation to the town's solicitor. In his private capacity, the petitioner performs planning work on a consultant basis. This includes providing expert reports and testimony on behalf of, or in opposition to, construction and development projects. He states that the most common type of consulting work that he does involves assisting homeowners with additions or major construction projects to their house or property, which trigger the need for zoning relief in front of a particular municipal board. The petitioner performs this work outside of his regular work hours for the town and without the use of public resources. He states that his private consulting work has never taken place or impacted a property or application within a municipality by which he was or is employed. Therefore, he has not been required to, nor will he be required to, appear before his own municipal agency or any other agency in a municipality employing him, including the town of Coventry, as part of his private employment. The petitioner informs that in his time as a private consulting planner, he has never had a client who was actively or previously before him in his public capacity, or who had a reasonable expectation of appearing before him in his public capacity. He does not use his public position to solicit business or customers for his private consulting work. He represents that in his time as a municipal planner, he has not provided guidance or otherwise acted on an application in his public capacity in which the applicant was an active or previous client or had a reasonable expectation of becoming a client. The petitioner further represents that he has never used, nor would he ever use, his public position to obtain or share confidential information as a means to aid his private interests or those of any family member, client, business associate. Petitioner states that certain abutters to the proposed village at Tyoke who appealed the decision of the planning commission to approve the application have alleged that the petitioner should have recused from participation in this matter in his public capacity in light of the private consulting work in which he engages, and further alleged that the petitioner has a business associate relationship with the applicant, Mr. DeBlois. Petitioner further states that the same abutters have suggested that the petitioner should just not engage in private planning consulting work of any kind while simultaneously serving as the town's director of planning and development during the pendency of the village at Tyoke application, including all appeals. The petitioner explains that this suggestion is likewise based on allegations that he and Mr. DeBlois are business associates. The petitioner emphasizes that he has never had, nor does he reasonably expect to have, a financial relationship with Mr. DeBlois, any DeBlois associated company, or with anyone else on the Village of Tyoke application team. The petitioner adds that he has never interacted with Mr. DeBlois or any DeBlois associated company other than in his public capacity. It is under this set of facts, the petitioner seeks advice from the Ethics Commission regarding whether he's prohibited from performing his official duties as to the appeal and working in his private capacity as a planning consultant. First, addressing the performance of his official duties. The Code of Ethics provides that a public official has an interest which is in substantial conflict with the proper discharge of his duties in the public interest if he has reason to believe or expect that he, any person within his family, a business associate, or any business by which he is employed or which he represents will derive a direct monetary gain or suffer a direct monetary loss by reason of his official activity. Here, the petitioner represents that he's never had, nor does he reasonably expect to have, a financial relationship with Mr. DeBlois, any DeBlois associated company, or with anyone else on the Village at Tyoke applicant team. Accordingly, as to this particular matter, it is the opinion of staff that the petitioner is not prohibited from continuing to perform his official duties relating to the appeal of the Planning Commission's approval of the Village at Tyoke application. Next, as regards to Mr. McLean's continued work in his private capacity. Rhode Island General Laws, Section 3614(5)B, affectionately known as the Secondary Employment Statute, addresses prohibits a public official from engaging in private employment that will either impair his independence of judgment as to his official duties or require or induce him to disclose confidential information acquired by him during the course of and by reason of his official duties. The Ethics Commission looks at a few things: the nexus between the official's public duties and his desired private employment, whether the public official completes this other work outside of his work for the municipality and without the use of public resources, whether the public official is required to appear before his own agency as part of his private employment, whether this other work is to be conducted outside of the areas over which the public official has decision-making jurisdiction in his public capacity, and whether or not the public official uses his public position to solicit business or customers for his private employment. The Ethics Commission regularly has allowed public officials and employees to engage in secondary private employment that was outside of their official public jurisdiction. Two prior advisory opinions addressing this issue appear on page 5 of the draft. Here, because the petitioner's public employment is limited to the town of Coventry, and the petitioner states that his private consulting work has never taken place at or impacted a property or application within the municipality by which he was or is employed, there is no indication that the petitioner's continued private employment would be in substantial conflict with his duties in the public interest or impair his independence of judgment as to his public duties. Accordingly, it is the opinion of staff that the petitioner is not prohibited by the Code of Ethics from continuing to work in his private capacity, consistent with the provisions outlined in the draft. I'm happy to address your questions or to defer to Mr. McLean as appropriate.
Mr. McLean, you've obviously had an opportunity to review the decision or the advisory opinion, and you've had a chance to talk to Ms. Radicious, I'm sure. Do you have any questions or concerns you'd like to bring to us?
No, I don't.
Members of the commission, does anybody have any questions for either Ms. Radicious or Mr. McLean? I appreciate your giving me the pronunciation.
Oh, I said McLean for a while.
Actually, McLean's right.
Oh, my God.
There you go. So I had it right for once. You're in the middle of an inside joke. I apologize, but
That's all right.
there being no further questions or comments, is there a motion to approve and issue the advisory opinion as presented by the staff in this manner?
So moved.
Motion by Commissioner Rabideau, second by Commissioner Callahan. Roll call vote, Commissioner Susie.
Aye.
Mr. Peterson.
Aye.
Mr. Browner.
Aye.
Mr. Callahan.
Aye.
Mr. Centerini.
Aye.
Commissioner Rabideau.
Aye.
Mr. Ritchie.
Aye.
Commissioner Strauss.
Aye.
And the chair votes aye. Thank you, Mr. McLean.
Thank you very much.
Appreciate you coming in.
I appreciate what you guys do.
Thank you. The next item is Shanna Curlin. Next sign up. Back.
The draft from Ms. Perlin is at tab B in your binders. This draft is somewhat unusual, but this situation does happen occasionally. There is a question presented, that is not the unusual part, but the draft contains two options for responses for the commission to consider. Facts are the facts, they are what they are. The applicable sections of the Code of Ethics do not change, regardless of the outcome, nor do the advisory opinions cited in the draft. After I summarize the facts, applicable code sections, and refer to one or more of the advisory opinions cited, I will offer option A's recommendation and the reason for it, followed by option B's recommendation and the reason for it. This draft was originally presented at the March 24th meeting. There were 7 commissioners present, but no AO issued because neither option A nor option B got the minimum required 5 votes. The suggestion was to try again at the meeting on April 14th, for which the petitioner had a work conflict and could not attend, so we are giving it another go today. Last December, the petitioner was appointed by the Providence City Council to serve as a board member of the Providence External Review Authority, that's PERA. PERA is a municipal agency that serves as a civilian oversight body that investigates allegations of police misconduct in Providence. PERA's board is composed of 9 members. Those board members do the following things. They create and implement community outreach programs. They examine police policies and practices and issue recommendations for changes to either or both to the police chief. They review allegations of misconduct on the part of Providence police officers by investigating, conducting hearings, and making findings of facts, which could lead to PERA's recommendation to the police chief regarding appropriate disciplinary action to be taken against the officers who are the subject of a sustained complaint. Complaints alleging police misconduct can be filed with PERA by any person, including but not limited to an alleged victim, a witness, a parent, legal guardian, or immediate family member of an alleged victim with personal knowledge of the incident. PERA may also initiate its own investigation of an alleged incident. PERA's review of a complaint alleging police misconduct could result in dismissal of the complaint, in forwarding the matter to mediation to the police department's director of internal investigations and inspections. They could place the complaint on hold pending the outcome of the police department's internal investigation, or they could transmit the complaint to para staff for a full investigation. Evidentiary hearings are conducted by a 3-member panel of para members who are randomly selected by para. In her private capacity, the petitioner works as a civil rights litigator in an of-counsel capacity to a Rhode Island firm, the focus of which is employment law. That firm also represents plaintiffs in civil cases alleging police misconduct. Those cases constitute about 10 to 15% of the firm's total cases. The petitioner explains that approximately 70% of her time at the firm is spent representing plaintiffs in police misconduct cases, and that most of those cases have named the Providence Police Department and certain of its officers as defendants. There are 8 open cases at the petitioner's firm which name the Providence Police Department and/or certain of its officers as defendants. None are the subject of a complaint before para. Nor does the petitioner expect any of the plaintiffs in those cases to supplement their civil complaint by filing a complaint with para, be it due to the expiration of the 1-year statute of limitations for doing that, or in the petitioner's opinion, filing a complaint with para being, after initiating a civil action, being superfluous. As of 2024, there were 449 Providence police officers. The petitioner states that in the event that the Code of Ethics does not prevent her simultaneous service on para's board and her private work as described, she will first represent those clients outside of her normal municipal service hours for para without the use of public resources. She will avoid appearing before para as part of her representation of clients suing the Providence Police Department and its officers. She will not use her public position as a member of para's board to solicit clients for herself or her business associates. She further states that she is prepared to do the following. First, she will not accept new clients who have an open case with para or who had an open case with para during her tenure on para's board. She will counsel new clients against duplicating their civil litigation efforts by filing a complaint with para. She will recuse from participation in all para matters in which an attorney from her firm appears. She will recuse from all para matters involving an officer who is a party or a witness in a pending civil case that she or any attorney from her firm filed or is otherwise involved in. She will recuse from all para matters involving a person who is a witness in a pending civil case that she or an attorney from her firm filed or is otherwise involved in. And she will refrain from disclosing confidential information acquired during the course of her service as a para board member to her clients, colleagues, or others. Looking now to the Code of Ethics. The draft includes references to the code's prohibitions against taking official action that will directly financially impact self, family member, business associate, or private employer. Use of their public office or confidential information received through holding it to obtain financial gain for that same core group of 4. Representing oneself or others or acting as an expert witness before a municipal agency of which one is a member. And also, a public official must recuse from participation in any matter in which her business associate or employer or another person authorized to act on their behalf appears or presents evidence or arguments before her municipal agency. This is predominantly a secondary employment issue addressed in Section 5B. No person subject to the Code of Ethics shall accept other employment which will either impair her independence of judgment as to her official duties or require or induce her to disclose confidential information acquired by her during the course of and by reason of those public duties. There is no inherent prohibition against someone subject to the Code of Ethics holding private employment that is secondary to their public position. In addition to the preservation of one's independence of judgment and the required non-disclosure of confidential information, the Ethics Commission examines several factors when considering potential conflicts regarding private employment. Those factors include, but are not limited to, the nexus between the official's public duties and desired private employment, whether the person completes such other work outside of their normal public service hours and without the use of public resources, whether the person is required to appear before her own agency as part of her private employment, whether such other work is to be conducted outside of the areas over which the person has decision-making jurisdiction in her public capacity, and whether the person uses her public position to solicit business or customers or her private employment. Looking at previous advisory opinions issued, the Ethics Commission regularly has allowed public officials and employees to engage in secondary private employment that was outside of their official public jurisdiction. For example, in advisory opinion 2006-17, which is cited on page 5 of the draft, a lieutenant with the East Providence Police Department could apply for a private investigator's license and operate that business in East Providence with certain conditions imposed, among them, that he have no involvement with matters subject to the East Providence Police Department's official jurisdiction, and that he not accept any cases or perform any work within the city of East Providence for as long as he was employed by that city's police department. A similar advisory opinion issued in 2001 to an active member of the Crystal Police Department. In advisory opinion 2016-16, an environmental health food specialist for the Rhode Island Department of Health was not prohibited from working on her own time and in her private capacity as a food safety consultant for food establishments in Connecticut and Massachusetts. The Ethics Commission determined that because the petitioner's public employment was limited to regions within Rhode Island and her private consulting work would occur outside of the state, it was unlikely that she would be performing consulting services in her private capacity where she performed inspections in her public capacity. For that reason, there was no indication that her private employment would be in substantial conflict with her duties in the public interest or objectively impair her independence of judgment as to her public duties. In the last two opinions cited in the draft on page 5, 2 investigative employees for the Division of Professional Regulation within the Rhode Island Department of Transportation could accept or maintain private employment in the professional fields for which they had investigative, licensing, and enforcement responsibilities, provided that, among other things, they did not perform such work within the state of Rhode Island. In the instant matter, notwithstanding the petitioner's ability and willingness to recuse from a myriad of situations in which a conflict of interest exists, this issue can be reduced to whether or not the petitioner's private employment as an attorney who regularly files civil cases on behalf of clients alleging misconduct by the Providence Police Department and its officers will objectively impair her independent judgment with respect to her public duties as a para board member, which adjudicates and regulates the conduct of the same department and its officers. Option A. The nexus between the petitioner's public duties and private employment can be sufficiently mitigated by the petitioner's recusal from the matters enumerated in the draft. Para does not exercise jurisdiction over the petitioner's practice of law, but rather over a particular area of law in which the petitioner concentrates her practice. Because the petitioner does not currently, and as a para board member may not appear before para, her clients will not be subjecting themselves to para's jurisdiction. This expands the nexus between the petitioner's public duties and her private employment because the petitioner will not be exercising jurisdiction over her private clients in her public capacity. The petitioner must complete all work for her private clients outside of her regular service hours for para without the use of public resources and may not use her public position to solicit business or clients for herself or her firm. She may not disclose confidential information acquired by her during the course of her para service. Not every situation in which a conflict of interest might arise can be anticipated at this time. Therefore, this draft provides only general guidance as to the application of the code based on the facts as represented herein. Petitioner is advised to remain vigilant about identifying potential conflicts of interest and to either recuse or seek further guidance from the Ethics Commission in the future as warranted. Option B. The nexus between the petitioner's public duties and private employment is too close to be sufficiently mitigated by the petitioner's recusal from para matters enumerated in the draft. The petitioner's multiple required recusals from performing essential duties in both her public and private positions serve only to highlight the inherent conflicts of interest embedded in serving in both capacities. If, for example, the petitioner were to file a civil action on behalf of a client alleging misconduct by a Providence police officer who previously appeared as the subject of a complaint before the petitioner as a para board member, the petitioner would be privy to confidential information acquired about that officer during para's executive session that she would not be able to extricate from her mind. Also, in addition to deciding matters alleging misconduct by the Providence Police Department and its officers, the para board participates in the creation of and/or modification of police policies and procedures to which those officers will be subject, including those involving officer discipline. The alleged violation of department policies and procedures that the petitioner helps create or modify will likely form the basis of complaints filed on behalf of her future private clients. Although para does not exercise jurisdiction over the petitioner's practice of law, it does exercise jurisdiction over the particular area of law in which the petitioner concentrates her practice. Although the petitioner's clients will not be subjecting themselves to para's jurisdiction, the police officers in the current and future private cases litigated by the petitioner and her firm are and will remain subject to para's jurisdiction nonetheless. That the petitioner's clients do not subject themselves to para's jurisdiction does not sufficiently expand the nexus between the petitioner's public duties and her private employment, because the alleged misconduct of Providence police officers is the very subject matter of both the majority of cases brought by the petitioner in her private capacity and those within para's official jurisdiction. Consistent with past advisory opinions issued, the totality of facts as represented indicate that the petitioner's private work objectively would impair her independence of judgment with regard to her public duties. Accordingly, the petitioner is prohibited from simultaneously serving as a para board member and working as an attorney who regularly represents clients in civil actions alleging misconduct against the Providence Police Department and its officers. Notably, the petitioner's representation of plaintiffs in civil actions alleging police misconduct in municipalities other than Providence while she serves on para's board would not violate the provisions of the Code of Ethics cited in the draft. I'm happy to answer your questions or to defer to Attorney Kurland as appropriate.
Thank you, Mr. Decius. This is not the first time we've been here, Ms. Curlin. I think what I'm gonna do, rather than ask you to, unless there's something additional to what has been presented, which I think is pretty much the same thing that happened before. I think I'd like to open it up to questions from the members of the commission.
That would be fine, Mr. Chairman.
Okay, thank you. Members of the commission, anyone who has any questions for Mr. Decius or Ms. Curland?
Well, I guess I have one.
Sure.
During the scope of your description, you used the term service hours fairly regularly. Ms. Curlin, what are the anticipated hours that are required for service on the para board on a weekly, monthly basis?
So I think I've got a few months in now enough to have a grasp on that. Mandatory, as near as I can tell, there's only one meeting a month that could run anywhere from 1 to possibly 3 hours, depending on how much material in executive session. And then the rest of it, from what I can see, is very voluntary. So I spent a couple hours at the sort of Ward 9 Resources Fair at the para table, but that was optional. And that was a Saturday. I didn't have any work stuff to do. It might be, you know, I spent an hour Sunday morning doing reviewing a proposed ordinance draft. Again, voluntary. I chose to take that time. So it seems anywhere from, let's say, 2 to 10. But generally evening and weekends, because most people have a daytime work schedule.
Thank you.
Other questions?
I just, perhaps you can help me clarify, your, Mr. Decius or Ms. Curtin. I'm putting myself in the shoes as an example of perhaps, someone within the Providence Police Department. And I'm wondering about the appearance of this impartial panel, theoretically, that's before, para, when I have a member of that panel whose really primary professional job is to bring civil litigation amongst police departments, but in this case, police department. And so it's more in line, I guess I'll caveat that with number one, I don't personally think that you're incapable of all of this, so that's not the point at all. I'm sort of shading to this appearance and the human on the other end who has knowledge of the profession of one of the members of the board. How do we distinguish that?
I'm happy to address that.
Please.
Is that okay, Ms. Collins? Okay, so the Rhode Island Ethics Commission very much embraces the state's constitutionally founded goal of avoiding the appearance of impropriety. As members of the public servants, we are to hold ourselves to a higher standard. So we very much embrace that. That having been said, taking part in a matter that in your public or private capacity that could carry with it an appearance of impropriety does not in and of itself violate the code of ethics. Okay, we have issued advisory opinions in the past saying pretty much just because you can doesn't mean you should, and we think the appearance of impropriety in this case is such that you should avoid taking this matter. That will we've done that. We've also said lightened that up a little by saying given the potential appearance of impropriety in this matter, we leave to the petitioner to decide whether or not will rise to the level such that they should abstain from the conduct in which they wish to engage. I drafted the opinion and both recommendations, options, without using the term appearance of impropriety. I did not see that it was necessary to do that, but I hope that answers your question.
Well, I would, so thank you. It's always very helpful. That I'm gonna scale that back to an appearance of fairness. That's a different word for me. Impropriety has, a couple layers to it. So it's fundamental fairness is what where I'm coming from.
Actually, that speaks to me anyway. That sounds closer to the potential impairment of one's independence of judgment, the inability to be fair. And citing one's potential impairments of independence of judgment is not a castigating remark in any way, shape, or form. This is not personal, because if you think about it, one's independence of judgment is subjective. I should be able to deliver an advisory opinion for my brother because I'm going to be fair. I'll treat him like I would anybody else. That's why the analysis of our independence of judgment at the Ethics Commission is really objective. We're looking at a few things, but when it comes down to it, we're looking at the nexus between the public duties and the potential private conduct and how closely they're related. And two, let I wrote it down because I'm just a little worn out. Oh yes, whether the work, as in this case, as a private attorney, is conducted outside of areas over which Ms. Kurland has decision-making jurisdiction in her public capacity. That's really what it is. That's objective. That's not saying you can't do this. How are you going to be fair? I would never say that, especially about this petitioner, having discussed this matter with her endlessly. So it's whether the two jobs are just too close, or whether this private employment takes place in the area over which she has jurisdiction in her public capacity. And the code has spoken to that. They want to see the nexus. Sometimes the nexus can be skirted, if you will, by making sure they're outside of the same jurisdiction. So that's what this comes down to. And the reason that this was written both ways is because arguably it's outside of the jurisdiction because the para doesn't regulate the practice of law. And that's what her job is, practice of law. It's inside the jurisdiction because even though para doesn't regulate the practice of law, It regulates the conduct of Providence police officers, who are really the subject of what the petitioner does.
See, just hit the nail on the head, I'm sorry. That last sentence. It monitors the behavior of Providence police officers. And if my job is to sue the Providence Police Department, I don't mean that, you know what I'm saying?
Sure.
If that's my job, then it is, again, it's not, and I probably said this inaccurately, so I apologize. It's not impropriety that I'm concerned about. It's not your ability to be fair. It is, in my opinion, at least worth discussing the person on the other side of the table in para, that police officer as an example, who has fundamental rights and all of the things that go with his or her, role and union, yada, yada. Can they come and feel that they have equality and a, non-biased start? Can they feel that way? That's where I was coming
I
from.
would love to respond, but I did see that Commissioner Brown.
So I apologize. I didn't mean to step on that one.
I'm trying to understand options A and B. I'm more prone to go with option B because it sounds like at the end of option A, Ms. Curlin is gonna have to come to this board every time there's a situation where there's a question about whether or not what option B says. Kind of what you're saying, that she can't do both.
So.
And go ahead, I'm just.
And I think, and maybe to underneath it all, and I'm actually very glad that you asked that question, Commissioner Callahan, because underneath it all, that I think is sort of the elephant in the room. And it's not, it is a question of, does this allow a path for someone with a particular bias related to their work life? In my case, it's, my community life, my belief system, etc., to be able to be fair to the people over which para has jurisdiction. And I think, I'm glad you used the word monitor, because as we discussed last time, para has zero ability to enforce anything within the Providence Police Department. It's monitor. It has more access to information, but beyond that, it has no more power than any of us sitting around this table do. Although, more than this. But I think the question about will it appear that I'm fair, it absolutely will not. The Providence Police, several individuals, and I think as an institution, it's fair to say, have a particular opinion based on decades of my work. It started well before para, well before I became a lawyer. But the thing is, we're grown-ups. We live in Rhode Island, where everybody is going to be bouncing off each other like molecules in some container. And so we've had to learn to deal with that and manage that. So for instance, I start off a deposition of Chief Perez by saying, and Chief Colonel, we acknowledge that you have in previous years arrested me, correct? He says, yes. I say, does that in any way make you uncomfortable to have me depose you this morning? He says, no, absolutely not. So we have learned to, because there's no option, we live, or they, in their case, work in a city that's not that big, and we're going to have encounters. In this case, this is about my role as a public servant, but my role under the First Amendment as a member of my community, who I believe has the responsibility to help care for my fellow community members. And so I bring that to the table, but every person brings some kind of bias. We've had former retired police officers that work on the para staff, and I think are bringing their bias, which is different than mine, but very helpful. Along with their knowledge, same as me. We have the city solicitor who sits in the meetings, including executive session, to advise us on Open Meetings Act, and she's great at it. And the next morning, actually that same morning, she and I are duking it out at a deposition where she represents her client faithfully. I represent my client well. She'll be defending the city against the claims potentially that are in para. I won't do that. Participate, but she'll be called to do it. I mean, barring whatever staff shakeups happen every so often. So it is ultimately, anybody could make a corrupt connection out of any situation. So yes, appearance is important. Some situations, obviously, you give the contract to your brother-in-law. Yeah, that's more obvious. but anybody could exploit it. I do not plan to do that. I know that I won't, and I'll be very cautious. Because I'm learning a lot through this process, if not about how to not do that as well. I'll just leave it with, in terms of sort of I feel like if I did a survey of people within police administration, and even certain police officers, they would appreciate that my rule is hate the game, not the player. And that's how I function, and they know that. So the ways I would actually strengthen this just a little bit, and make a couple adjustments, including making sure I don't wrongly counsel a potential client to not going to para, which the chairman brought up last time. And that's something I want to be conscious of. But I mean, in closing, it's really from the police department's view. I had told Colonel Clemens once when we were discussing my involvement in something, a comment that had been made by my late ex-husband, who he had great admiration for as well. And it was that sometimes you want to have the skunk inside the tent spraying out. So just leave it at that.
Thank you.
Mr. Senator.
Do all of the matters that you represent clients regarding alleged police brutality or wrongdoing are all those cases involving Providence, or do you have cases outside of Providence?
I have some outside of Providence. About 2/3 are Providence cases.
Well, I would have less concern if you have no cases within the city of Providence, and if, you were on the para board. I see that as a fact that's in my decision-making process, ma'am. But how many cases do you have in Providence, either with your lead or assistant counsel?
Sure, at the moment, and I lost count, I did send Ms. Radishes an update, 8, and it's almost down to 7. Very close, it's in theory 7. But one thing I would like to though add is these are 2 different tracks. Para complaints, they can go to litigation. I have never litigated a case where the person went to para. We tend to see those as helpful for smaller types of issues and complaints. Litigation, para has no jurisdiction over what happens in litigation. And those generally, I've never had a case that went to that where the person approached para.
Mr. Ritchie.
Morning, Council.
Good morning, Commissioner.
You may recall I asked you the last time. Did you apply for this position, or did someone ask you to serve? You said you applied for it.
Yes, well, I did as a last minute when I was trying to recruit some younger folks.
That's what bothers me so this week. You're obviously very confident in the field within attorney practice. I don't understand why you would want to serve on this board. I'm not gonna try and get into your head, but let's certainly regard as a really happening individual. I just don't see why you would, because it does pose a problem for me in this situation. When you, if you were to serve on this board, you could conceivably advertise that you are a member of PIRA. And therefore, let it be known to outside the Providence community that you are a member of PIRA, that your experience and so forth will be advantageous to your firm. Not suggesting that's your goal, like any stretch of imagination. That is shall we say, a nice consequence of it.
So, and to address that, I had mentioned last time, this is not a profitable endeavor. There's only been one out of all the police misconduct cases the firm's handled that we have not lost money on. So we're definitely not advertising. Folks already know me, and if they're inclined to, will call me, and same with the firm, because we're one of the only firms that does this work. So I think that would make sense logically. It's just not the reality of the economic reality of police misconduct litigation. We lose money. We don't want people calling us for the cases. The question about why I put in my name, and again, as I mentioned, it was there was a number of openings at the last minute. And what I saw happening was a number of new members coming on who would bring great community experience or life experience, but might not have as direct institutional knowledge to be able to share news with the committee or with the history. So I jumped in and said, okay, go ahead, when's it due? Fine, grab me. And I see my role there as being able to bring that experience and share it so that the folks that are gonna stay around for a long time can do it. I don't need another activity on my list. I see that happening now as there's comment on an ordinance, and I can bring in, link to the Providence Police policy that affects it, and I can share that knowledge with folks. They didn't tell us which of the staggered terms each of us is filling. I would be more than happy to request that my name be put on one of the shorter staggered terms so that I can get in, get out. And in the meantime, there's a number of younger people and kind of, just work to make sure everybody's caught up. We got the good training programs, and I've had impact onto what they're getting trained on. I would be happy to do that, even if the Ethics Commission wanted it as a condition. And again, in terms of, everything we do, I can say, oh, I know how about the Ethics Commission comes from, because I've works, and that adds to my professional cachet in a way. Just from every experience we have, right? Somebody who's on the Character and Fitness Committee, an attorney, that looks very good on their resume, I would think. That's going to increase their credibility, and clients will like them. So everything we do has that impact. In my case, I think there's probably other work I've done that brings in those calls. And I would definitely not want to do anything that's going to increase those calls.
I have one comment. I think what highlights the difference for me is actually an example you said, which is that there's some former retired police officers who are serving on para. You're not retired. You're going to be doing both. And I think that's why, to me, the nexus is too close. I appreciate that you want to bring your expertise, and that's wonderful. But I think that that's the distinction for me, is that, and I agree that we all bring our biases to things. I have on my website that I'm on this commission, so I have no problem if you were to put this on a website that you serve and board. That's completely reasonable. For me, it's the nexus between the work you're doing and the activities covered. The other issue is that it's not just your clients that can file para complaints. It's witnesses, it's family members. It seems like there's really a broader scope of people that could kind of get this a little out of control for you. And I do have concerns like Dr. Browner that you would either be here or having to choose yourself so frequently that it would, be cumbersome. I think there are sort of 2/3 of the work that para does that doesn't have that nexus for me. I can see how it would be really helpful to have you talking about the outreach programs, working on those, examining policies and practices and recommending changes. Those all seem in line with something you could do, but it's really the review of the allegation of misconduct that's too tight of a nexus for me.
Any other questions or comments? Commissioner Susan?
Good morning. I have a couple questions. You said that, well, maybe I took this the wrong way, but I think you implied that the para board doesn't have power.
Officially, I would state that,
But it
not
does,
official power.
but para is able to initiate its own investigations and it has subpoena power. That's power.
Para's subpoena power has come through the city council, unless there was a recent amendment I missed, which there could have been.
Okay, that was a note that I took. The other comment I have is that you had said that you're prepared to do the following, and one of them was counsel new clients against duplicating their civil litigation efforts.
Thank you for catching that, and I had it circled on my page. We did briefly touch on it as Chairman Jones raised that point. That I would not do because that would not be fair to the clients. What, an example, I had a call a couple weeks after I was here. The gentleman was relating what happened to him. In my mind, I'm thinking that's not a case we're gonna take. Even if we could, I'm gonna suggest he called Para, and that's exactly what I would have done, the same thing, in fact, from beforehand, sort of trying to find the right track. This goes over here, that goes over there.
Like, I mean, I'll just kind of echo, like, I appreciate you coming before us, and like, I would just comment that the appearance of impropriety piece, it's nothing personal. It's just, I do feel, with all the potential recusals and conditions that you would need to abide by in order to draw that line, I feel like we're trying to put a square peg in a round hole here.
It's, honestly, and I understand that we have to look at, hope for the best and to expect the worst. There would be the only different thing than what I currently do in my practice, based on what I have to do anyway, would be that if there is a hearing, and the number of hearings, like, hopefully it'll get up and running to the point where there will be a few within a year. There have been, I don't even know if there've been 3 happening in all. They're extremely rare. The chances of, because that was the first, oh shoot, is there overlap? No, none. So the chances are so infinitesimal that would happen, and I'd know it. I wouldn't, we have 9 board members, you need 3 for a hearing panel. The chances are even good if there were hearings, and if there was somebody where there was overlap, witness or defendant, that's already such a small chance. And then it would be a very rare recusal, and I could easily recuse. It's just not something that happens much.
Just a quick note, page 2, the 3rd note down, the petitioner further informs that Para has full subpoena power.
Okay, so that was, and I thank you for the correction from Attorney Radicius. It was, it was that they had to go through city council, and then that did make it into a round of amendments. Okay, so I stand corrected on that.
I'm sorry, which way?
Yeah, that's.
That Para does now have the subpoena power.
All right.
That was an amendment to the ordinance that did go through. But again, that hasn't been utilized much, and that's the director runs that, and the director spent many years as a police deputy director, I believe, is very capable of standing up to me without any problem.
You're on the board.
Yes, I'm on the board.
Right, so-
I don't have control over his hiring. That's done by the city council.
I mean, I also, sorry, just a comment one more, I also think, like, in the context of, your job as an attorney is obviously more important than this and a
I
priority.
don't know.
And I would just say, like, sitting on the other side of the table as counsel for a defendant, I would investigate, your role in Para and see if I could, use it against you, frankly. And
Counsel counsel for the defendants, the very, very skilled attorney. He already knows all about my connections, and interestingly, the main opposition is not coming from his office, from police department, it's coming from the mayor's office.
Okay.
When you say opposition, you mean to your presence?
It's in my participation in Para,
It's coming from the mayor's office.
correct?
Any other questions, comments?
I have, I feel responsible,
Just a moment.
yes,
I do. I'm not
Oh,
done yet.
thank
If you're not making money, why even do it? Why do the cases?
Everybody's got to be alive for some kind of reason. And I found this to be sort of, when I was in 5th grade, I wanted to be a nun. Things didn't work out that way. So, no, it's literally, this is an evolution of the work that I feel called to do in my life. I'm part of, being in a community, trying to find a way to make my skills do something to make the world better.
And again, it's been made clear here. I mean, I know you, we've known each other for quite a while. We're not business associates.
No financial.
And I certainly appreciate, I litigated the existence of para a long, long time ago. And so I do know what it's about, and I do appreciate your being there. I think you indeed would be a very good presence on para. My problem is, as with other members here, is I just think the nexus is too close. I recognize we don't regulate your conduct as a lawyer. That's a whole different problem. But from the perspective that I look at it, I just don't see how you can do that job on para and not have it bleed into your private work. Just doesn't. Well, let me ask you one other question, but to me, I can't make it fit, but the board does have the authority to recommend or to propose changes to the policies and practices and rules of the department, correct?
Yes, that's.
So that would be based on things you've learned. Now, take it forward a year. You've gotten that policy changed. And now you have a claim that, gee, that policy is being violated, even though it wouldn't have violated the prior policy. And now the connection becomes almost, Gordian.
And again, if we had some ham, we could have some ham and eggs. If we had some eggs, as my mom would say. The policies, the written policies, they buy the police department contracts with CALIA, the National Accreditation Agency, and that's really where the vast bulk of the policies, the actual wording and text comes from. Okay, we wanted to cover this and this, give us that. And so the policies generally aren't a problem. It's very rare that I haven't even thought of wanted a policy change. There's practice changes, sure, but the policies themselves. So the chances that, that it would, the issue is the following the policies and the dissemination practice and everything. So I could bring that information to para about how the powered VMS system works and that you might want to look at that instead. But I'm already doing that. It would just be sharing that info with para, what I've learned in my work. So in that case, what para is able to do, make a recommendation I can't see how that would have an impact, because we look for, anyway, the written policies are always fine. We need the unwritten, the custom and practice it's called anyway, to be able to litigate against the city. So the written policies don't affect our work. And unfortunately, I don't think that they affect the Providence police work always.
They do provide a foundation.
For what they do, but generally the policies are written correctly legally, the law department reviews them. So the policies are what they use all night to say, hey, we're doing it correctly, because in writing they are. So yeah, that's.
Any other questions, comments? I'm gonna do this first. I'm gonna do option A first. Is there a motion to approve and issue the advisory opinion as presented by the staff in option A? That the petitioner is not prohibited by the Code of Ethics from serving on the board of the Providence External Review Authority, notwithstanding her private employment as a licensed attorney who regularly represents clients in civil cases alleging misconduct against the Providence Police Department and its officers. Is there such a motion? Not hearing. I'll go to option B. Is there a motion to approve and issue the advisory opinion as presented by the staff in option B, that the petitioner is prohibited by the Code of Ethics from serving on the board of the Providence External Review Authority, given her private employment as a licensed attorney who regularly represents clients in civil cases alleging misconduct against the Providence Police Department and its officers? Is there such a motion?
So moved.
Motion by Commissioner Brown, is there a second?
Second.
Second by Commissioner Santorini. Any further comment or discussion? Seeing none, hearing none, a roll call vote. And the roll call vote would be that the answer to her is no. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Santorini.
Aye.
Mr. Rabideau,
Aye.
Commissioner Ritchie,
Aye.
Mr. Strauss,
Aye.
and the chair regrettably votes aye as well.
Thank you for your time. I appreciate it. And just to clarify, I haven't done this process before. This is the advisory committee or the advisory opinion, so that if it's not an order not to proceed as such, but if I do, and it turns out I do commit a violation, I'm on my own.
That is exactly correct. I'm
Okay.
sure if it weren't, Mr. Graham would quickly correct that, but it's, you can exercise your conduct as you see fit. If someone brings a complaint, then you have no advisory opinion to provide you with safe harbor. It also doesn't mean we've decided that complaint.
Correct.
So let's just be clear about that.
I understand and I appreciate it. And I also want to just take a minute and very much thank Attorney Radishes, because I know she put a lot of very thoughtful, good work into it.
Thank you very much.
Thank you.
Next person on the sign. Next person signed up is Charles Roberts. I'm sorry, I skipped Anthony Pompey.
The draft for this petitioner is at tab A in your binders. Welcome, Mr. Pompey. This advisory opinion was sent to Mr. Pompey on April 24th with what's called a safe harbor cover letter. That is used only on certain occasions when the executive director is somewhat able to anticipate the approval of a draft recommending that a petitioner be permitted to engage in the activity about which he inquired, and when the matter is indeed time sensitive. The cover letter that went to Mr. Pompey included the following sentence: however, you may act from this date forward, consistent with this draft opinion, unless and until you are advised that the commission has voted to not approve it. So with that, the petitioner is an assistant director for administrative services for the Rhode Island Department of Transportation. He has asked for an advisory opinion regarding whether he is prohibited from participating in the selection of a construction company to provide construction phase services on a bridge project, and potentially from all other matters concerning the selected company for the duration of the project, given that his spouse's first cousin is employed by one of the companies that submitted a bid on the project. Mr. Pompey has worked for RIDOT for the last 22 years. He has held his current position for the last 2 years. His duties include responsibility for overseeing the administration and management of various construction projects from initiation to closeout. He is tasked with reviewing and scoring submitted proposals for construction projects. There is one such project pending for which bids have been submitted in response to a request for proposal. One of the bids came from Green International Affiliates. The petitioner's spouse's first cousin has been employed by Green as a staff engineer for the last 10 years. Under the Code of Ethics, the first cousin of the petitioner's spouse is his family member. The cousin is not listed anywhere in the bid from Green, including the proposed organizational chart provided by Green, identifying the team members that would be working on the project. The cousin is a salaried employee whose salary would not be impacted in any way if Green is awarded the contract or not awarded the contract. The cousin was not aware of the proposal process, the project, or even his employer's interest in it. If Green is awarded the project, the petitioner's spouse's first cousin in law does not expect to perform work related to it. Petitioner clarifies that in the event Green is awarded the contract and the cousin is asked to perform a task by his supervisor, it would likely be an engineering plan review in the background as part of a larger task. Petitioner's cousin-in-law's position with Green is fully technical. It does not involve his interaction with clients. The Code of Ethics prohibits a public employee from taking official action if it is reasonably foreseeable. What we mean by that is the conflict is more than conceivable, but less than certain to occur, that will directly financially impact, among others, a member of his family. Nor can a public official use his public position or confidential information received through holding it to obtain financial gain for any person within his family. A public employee must recuse from participating in his official capacity from any matter when a family member appears or presents evidence or arguments before his public agency. Finally, the Code of Ethics does not allow a public employee to participate in any matter as part of his public duties if he has reason to believe or expect that any person within his family is a party to or a participant in such matter, or will derive a direct monetary gain, suffer a direct monetary loss, or somehow obtain an employment advantage. The Ethics Commission has previously opined that a person subject to the Code of Ethics could not prepare requests for proposals, review bids, or participate in the selection of vendors for construction projects when it was reasonably foreseeable that a family member, business associate, or employer of the person might be involved and or otherwise directly financially impacted. The code does not, however, generally require a public official to recuse from participating in matters that involve or financially impact a family member's business associate or employer, unless there is some corresponding financial benefit that flows down to the family member. 3 examples are cited in the graph at the bottom of page 3 and the top of page 4. Here, the facts as represented do not indicate that the petitioner has any reason to believe or expect that his spouse's cousin would be directly financially impacted by reason of his, the petitioner's, official activity for RIDOT in relation to the selection of a construction company for the project, or if Green is the selected bidder in other matters concerning Green for the duration of the project. Again, the cousin's salary employee's compensation is not going to be impacted by the selection or non-selection of Green. If Green is selected, the petitioner's cousin-in-law would have no expectation of being involved in the project. At the very, at least in the front row, if and when he was tapped to do something, it would be in the background. And the cousin's position with the company, again, is fully technical. He doesn't interact with the clients. Based on all of the foregoing, it is the opinion of staff that the petitioner is not prohibited by the Code of Ethics from participating in the selection of a construction company to provide construction phase services on a bridge project. And if Green is awarded the contract from all other matters for the duration of the project, notwithstanding that his spouse's first cousin is employed by Green. This advisory opinion cannot anticipate every possible situation in which a conflict might arise. And Mr. Pompey is reminded that this is general guidance based on the facts as they appear. We invite him to remain vigilant and urge him to do so about identifying potential conflicts of interest. Say his cousin somehow becomes president of the company or takes another position, or he takes another position in the future. I'm happy to answer your questions or to defer to Mr. Pompey as you see appropriate.
Thank you, Mr. Decius. Mr. Pompey, you've seen the advisory opinion before you came here, and you've worked with Mr. Decius, I'm sure, to get to where you are. Do you have any questions, comments, concerns about the opinion?
No, I do not.
Members of the commission, does anyone have a question or concern to raise with either Mr. Decius or with Mr. Pompey? Hearing none, is there a motion to approve and issue the advisory opinion as presented by the staff? Motion by Commissioner Ritchie, second by Commissioner Callahan. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Mr. Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Strauss.
Aye.
And the chair votes aye. Thank you very much, Mr. Pompey.
Thank you very much.
Now I have Mr. Roberts. Morning, sir.
Morning.
Good morning, commissioners. This draft advisory opinion is in the top in your binders. Mr. Roberts is a member of the Middletown Town Council. He requests an advisory opinion regarding whether he is prohibited by the Code of Ethics from participating in Town Council's discussions and decision-making relative to a potential regionalization of the Middletown School District with the Newport School District, given that his brother-in-law is the chairperson of the Newport School Committee. He represents the town of Middletown, and the Newport and the city of Newport have been in active discussions regarding the possibility of regionalization of school districts. He represents that his participation in that discussion and decision making on the town council has been questioned recently, given that his brother-in-law is on the Newport School Committee, And he suggested that his brother-in-law will be impacted should the two school district join together and form one regional school committee. The petitioner represents that thus far, discussions concerning potential regionalization of the school district are solely between the two councils. Without the participation of the school committees, in those municipalities. The Middletown Town Council does meet separately with their school committee, with the Middletown School Committee on the matter. I had discussions with the Middletown Town Solicitor, and he explained that the Middletown Town Council and the Newport City Council created an academic integration advisory committee to explore the possible education benefits and the economic impact of creating one school district, and to make recommendations regarding the general structure and organization of the regional school district. However, Mr. Roberts' brother-in-law is not a member of that committee. Mr. Roberts does not expect his brother-in-law to participate in any meetings between the town council and board city council. He assumes that it's possible if there are joint meetings and the two councils decide to have a public hearing, that members of the school committees may be present at those meetings during the public hearings or the public comment portion of those hearings. To present their own viewpoints, but they will not be present at actual joint council meetings. The town solicitor explained that in order to create a regional school district, the two communities will undergo separate processes. The Middletown Town Council will first vote to send proposed legislation for the formation of the regional school district to the Rhode Island General Assembly for approval. If that legislation is approved, then the town council will vote to put the question out to vote and approval by the town's registered voters. The town solicitor also explained that the same process will be conducted in Newport. The petitioner states that if a regional school district is created, the respective school committees will eventually cease to exist, and one joint school committee will be formed thereafter, and new members will be elected to that joint group. Now, under the Code of Ethics, a public official may not participate in any matter that would directly financially impact any a person within their family. Additionally, under regulation 1.2.1, a public official must recuse from participation in any matter if any person within his family appears or presents evidence or arguments before their municipal agency, unless one of two exceptions apply. One of the exception is if the family member appears solely in their official capacity as a member of or employee of another state and municipal agency to participate in non-adversarial information sharing or coordination of activities between the two agencies, provided that the family member is not a party or participant to that matter and has no personal financial interest in the matter. The other one is if the family member is before the person's state or municipal agency during a period of public comment, and provided again that the person is not a party or participant to that matter, it will not be financial, it doesn't have a financial interest in it. I have listed several, so I have listed somewhat similar past advisory opinions on page 4 of the draft. Here, similar to those facts, the facts in the past advisory opinions, the potential financial impact of the regionalization upon the petitioner's brother-in-law is both hypothetical and indirect. Further, the petitioner states that to date, the brother-in-law has not appeared before the Middletown Town Council, and he does not expect him to appear. However, even if hypothetically the petitioner's brother-in-law was to appear in a joint hearing or during public comment, it's very likely that one of those two exceptions that I presented would apply. However, we don't have any specific facts today presented, so we cannot opine on that. The petitioner is advised to seek further guidance if that happens. An inclusion based on all represented, prior advisory opinion, relevant provisions of the Code of Ethics. It is the opinion of the staff that the petitioner can continue to participate in the town council's discussions and decision making relative to the original organization of those two districts, notwithstanding that his brother-in-law serves on the Newport School Committee. Have to answer any questions you may have at this time.
Thank you, Ms. Papa. I'll turn to Mr. Roberts first. You've obviously seen the draft advisory opinion. You've worked with Ms. Papa to get there. Do you have any questions, concerns that you'd like to bring to us, discussion?
No, I think she's done a very good job of putting this together. I just want to stress that the council will not be voting on regionalization, just to turn it over to the voters, and that's where I stand. I want the voters to decide that.
So in the end, the council has no control over the final vote.
Correct, the voters.
Commissioner, have any questions, concerns? Ask either Ms. Papa or Mr. Roberts. Not seeing any. Is there a motion to approve and issue the advisory opinion as presented by the staff? So motion by Commissioner Ritchie. Is there a second?
Second.
Second by Commissioner Rabideau. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner.
Aye.
Mr. Callahan.
Aye.
Commissioner Centerini.
Aye.
Mr. Rabideau.
Aye.
Mr. Ritchie. Mr. Strauss. Aye. The chair votes aye. Thank you.
Thank you.
Appreciate you coming in.
Thank you.
You're going?
One note, we're about an hour and a half in. I don't know if you wanted to consider a short break.
We can have a short break. We'll just run through them.
How many more do we, will be more power to you?
Keep on moving. That's my vote, but I appreciate the heads up on the time. The next one is not from the list, so from the agenda.
Mr. Berlinski.
Mr. Berlinski. Mr. Berlinski here?
He's not present today. He indicated, he left me a voicemail that he's away and he will not be present. And if I'm not mistaken, my initial conversation with him, he expressed the willingness to go forward. Because he would like to, if the advisory opinion is approved, then he would like to proceed with his application for the zoning board. I have to note one typo on page 4. On the top of the page, it starts with however, section 36-14-5.1. We don't have 5.1. It's 5E1.
I'm so sorry, what tab are we at?
D.
Thank
D
you.
as in David. And then page 4. So I'm just corrected to say 36-14-5E and then the rest stays. May I proceed?
Of course.
So Mr. Berlinski, he's an alternate member of the Newport Zoning Board of Review. All my 3 advisory opinions involve members of either Newport, Middletown. So he's an alternate member of the Newport Zoning Board of Review. He requests an advisory opinion regarding whether he qualifies for a hardship exception, allowing him to appear before his own board. He was appointed to the position by the city council, by the city council in June of 2025. As an alternate member, he attends all the meetings, he participates in the discussions. However, he only takes moment if for some reason one of the city members is not refuses or otherwise is not available to vote. And Mr. Berlinski is required to replace that member. Currently, he's currently planning renovations to his home that include the construction of a second floor deck that would extend over an addition and a first floor deck located off the addition. The proposed second floor deck size exceeds the permitted 100 square feet deck size that is allowed under the newly amended zoning ordinance. He will have to apply and receive a dimensional variance from the zoning board in order to construct that proposed second deck floor deck. He has already submitted the proposed those construction plans to the building inspector, and he has been advised that he should seek advice from the ethics commission for that application is forwarded to the zoning board. He has owned the home for approximately 9.5 years, and he has lived in that home for approximately a year and a half. This represents that this is his primary residence. It does not rent out his home. The commission views questions of hardship on a case basis and has in the past considered some of the following factors. Whether the subject property involved the public official's principal residence or the principal place of business. Whether the public official's interest in the property was pre-existing in his public office or it was recently acquired. Whether the relief sought involved a new commercial venture or an existing business, and whether the matter involved a significant economic impact. That this commission may consider, of course, other factors and no single factors. Several advisory opinions are listed on page 3 of the draft. Here, he seeks to obtain dimensional variance in order to construct that second floor deck at his personal residence. The purchase of his home dates his appointment to the zoning board and the reliefs personal as opposed to a commercial venture. It is the opinion of the staff that the totality of the circumstances here justifies the granting of the exception and for him to appear before his own board to seek the variance. However, in addition to the code's requirement that the petitioner recuse from participation in his discussion of his own matter, he also must prior to or at the time of the appearance before the zoning board inform the other zoning board members of the receipt of the instant advisory opinion and that he will be recusing. Notice of recusal shall be pursuant to section 36-14. That's also any questions.
Commissioners, questions for Ms. Papa? Hearing none. And I'll ask Mr. Grammett this before we move forward. Is the correction that Ms. Papa presented to us an amendment of the advisory opinion, or is it merely a correction of a typographical error?
I would ask that you consider it just a typo.
So with that having been said, is there a motion to approve and issue the advisory opinion as presented by the staff?
So moved.
Motion by Commissioner Callahan, is there a second?
Second.
Second by Commissioner Susie. A roll call vote, Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Centerini.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Strauss.
Aye.
Commissioner, well, I vote aye as well. And the last one is Stephen B. Cutler. I don't think
Right.
Mr. Cutler is here either.
He's not present. That advisory opinion is at the top F. As you noted, Mr. Butler is not present today. He sent an email that he will be attending the meeting. However, he, to the best of his knowledge, the facts are correct. So we can proceed with the review of the draft. Mr. Hutler is a member of the Middletown Planning Board. In his private capacity, he is a member of the Board of Trustees of the Whitney Island Land Trust. He represents the Land Trust is a private nonprofit organization. Before the Planning Board is an application for a master plan approval for a major land development project involving property that is subject to a conservation easement in favor of the land trust and the applicant and the petitioner are acquaintances. Therefore, the petitioner requests an advisory opinion regarding whether he is prohibited by the Code of Ethics from participating in discussion and decision making relative to that application. The petitioner explains that prior to submitting the application to the planning board, the applicant had asked the land trust whether the proposed land development will be in violation of the easement. The petitioner represents that the land trust or the board, without his participation, had issued a statement that had made its way to the planning board and also it's published on the land trust website that states that the proposed development would not violate the terms of the easement agreement. The statement also describes the easement as a voluntary legal agreement between a landowner and a land trust, a government agency that permanently protects a property's conservation values by restricting certain development or land uses while preserving certain rights of the landowner. Currently, the petitioner represents that the land trust is not a party to the application, but it is possible that the land trust or members of its board of trustees could appear before the planning board during the public portion of the hearings. Or it could potentially object to the proposed development if any of the proposed portion of the proposed development changes. The petitioner also represents that he is acquainted on a personal level with the applicant and the applicant's spouse. The petitioner describes their relationship as civic collaboration as opposed to business or financial one. I have described the extent of their relationship in more details in the draft. Here, based on the facts as represented, the petitioner is not a business associate of either the applicant or the applicant's spouse. However, the petitioner is a business associate of the land trust by virtue of his service on the board of trustees. Therefore, the petitioner will be required to recuse from any matter that involves or impacts the land trust. In the instant matter, the land trust holds a conservation easement over a portion of the land that is subject of the application. Thus, the land trust has a legal interest in the land or portion of the land that is subject to the major land development application. The Ethics Commission has in the past considered similar analogous fact pattern in advisory opinion 99-91. The Ethics Commission there advised a member of the Jamestown Planning Commission to recuse from any matter before the Planning Commission that related to land on which that petitioner had an easement, because it was foreseeable that any action on the part of the planning board relating to such land would financially impact that petitioner. Accordingly, based on all represented, it is the opinion of the staff that the petitioner is prohibited by the Code of Ethics from participating in planning board discussions and decision making relative to that application. And should be pursuant to section 36-14-6. So questions you may have.
Members of the commission, anyone have a question or concern to raise with this pop-up? Hearing none, is there a motion to approve the advisory opinion as presented by staff?
So moved.
Motion by Commissioner Rabideau, is there a second? Second by Commissioner Callahan, roll call vote, Commissioner Susie.
Aye.
Mr. Peterson,
Aye.
Browner,
Aye.
Mr. Callahan.
Aye.
Mr. Centerini,
Aye.
Mr. Rabideau,
Aye.
Mr. Ritchie. Mr. Strauss.
Aye.
And the chair votes aye. That concludes the advisory opinions. The next item on the agenda is a motion to go into executive session to wit, a motion to approve the minutes of the executive session held on April 14th, 2026. Pursuant to RI General Law, section 42-46-5, paren A, paren 2, and paren 4, and then a motion to return to open session rather. Is there a motion to go into executive session?
So moved.
Motion by Commissioner Centarini, is there a second?
Second.
Second by Commissioner Peterson, roll call vote, Commissioner Susie,
Aye.
Commissioner Peterson,
Aye.
Commissioner Browner,
Aye.
Mr. Callahan,
Aye.
Mr. Centarini.
Aye.
Commissioner Rabideau,
Aye.
Commissioner Ritchie.
Aye.
Commissioner Strauss.
Aye.
And the chair votes aye. And we'll now go into executive session.
Moment.
Stretch out that.